of injury to an elderly individual from March 16th, 2026. And how do you plead to that charge?
Plead guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And did you plead guilty because you actually did what they charged you with?
No, I'm just ready to do my time.
Well, it doesn't work like that. If you didn't do this, then you get a trial. So here's the thing before you go any further. When you stood over in front of the clerk a minute ago, you raised your right hand and you said you promised to tell the truth, the whole truth, right?
Yes.
So if you're guilty, you're guilty. If you're not guilty, then we'll get your case set for trial. But I'm not going to allow you to plead guilty with something you didn't do.
Yes, ma'am.
Okay, so if you want to talk to Mr. Lewis for a minute again, that's fine. If you're going to take responsibility, will your client waive the formal reading of the motion?
You do it, Judge.
Mr. Denton, in cause number 21-37744, I have a motion to revoke the community supervision. Shows that you were placed on probation October 20th of 2021 for the offense of assault on a peace officer, a second-degree felony, and that was a 10-year prison sentence that was probated for 10 years. Is that correct? This motion alleges that you violated your probation. It alleges in count 1 that you failed to report to the probation office as ordered September 26th, October 17th, November 13th, and December 1st of 2025. And is that true or not true?
True, Your Honor.
Count 2 alleges that you failed to immediately report your home address and phone number also to the probation office as required. Is that true or not true?
It's true, Your Honor.
Count 4 alleges, I'm going to dismiss 3. Count 4 alleges that you failed to be placed on the mental health initiative caseload as ordered due to the fact that you absconded and you were unavailable for placement. Is that true or not true?
Yes, ma'am, that's true. I had
Count.
difficulties.
I'm sorry?
I had some difficulties. They stole my medications from my backpack at the bus stop, and I just...
Okay. Count 5 alleges that you failed to successfully complete the BIP program. Is that true or not true?
The what program?
BIP, the battering intervention and...
This is true, yes.
Okay. I think with the agreement, if y'all are okay, that's fine.
9 was the failure to complete.
There we go. 9, count 9 alleges that you failed to enter and successfully complete the Safe P outpatient aftercare. Is that true or not true?
Aftercare is from I successfully completed this.
Right. This is just the aftercare. You got to do the whole thing.
Yes, ma'am.
All right. Did you enter your pleas of true to counts 1, 2, 4, 5, and 9 freely and voluntarily?
True. Right.
And did you plead true to those counts that you pled true to freely and voluntarily?
Yes.
Okay. And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Denton is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 4, 5, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke the probation. Reassess your punishment in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
Yeah, he was on strike probation. He definitely beat that.
Well, his was in 21, and I think we started, I think it was 22 or 3 when I started reading it. So in my mind, if it was 22 or before, because I can't remember, I just do it again.
Yeah. Right.
I can't remember the exact day. And I need to say so many more words today.
That's what I was waiting. Sounded like we only had you for a little bit this morning.
Yeah, luckily it's not a big day. Let's see. Perry Heard. Good morning. Are you Perry Heard Jr.? I'm sorry.
Right.
Okay. And this is cause number 26 DCCR 0052. Mr. Heard is charged with harassment of a public servant. I'm going to take judicial notice of the court's file. I received a report from Dr. Capon with regard to competency, and that report is dated June 23rd of 2026. The finding in the report is that Mr. Heard is competent to stand trial. Is there any other evidence with regard to competency?
No, Judge. Not from the state.
Right, that at this time, based on that report, I am going to find that Mr. Heard is competent to stand trial. And what is the announcement?
Judge, I have received a new offer this morning since visiting with Mr. Hurd in regards to his offense, Judge, and I think it's something that could possibly resolve this issue. If I can just get a short reset in so I can explain that and go over with
Sure.
Mr. Hurd.
You want a week or two?
About 2 weeks.
Okay, we'll reset the case 2 weeks. Mr. Heard, Mr. Lewis will be out there to go out and visit with you about all your options, and we'll get an announcement at the next court date.
This is the court date for the day, right?
I'm sorry?
So this is my court date.
Today's your court date, but I'm going to move it for 2 weeks so that Mr. Lewis can spend some more time with you going over everything, okay?
All right, so I've been in there long enough to let's see if I need time served or how.
Talk to Mr. Lewis about all your options, and he'll let you know what they are, okay? All right, he'll be out there to go over all of it and make sure.
It's looking good for him.
He'll be out there to go over all that, okay? You can go back with the bailiff.
I'm gonna talk to y'all whenever.
All right.
No problem.
Denisha McMillan.
Yes.
Morning, ma'am. Are you Denisha McMillan?
Yes, ma'am.
And this is cause number 26 DCCR 0647. And I'm going to take judicial notice of the court's file in Ms. McMillan's case. Ms. McMillan was evaluated for competency to stand trial by Dr. Capon. I received that report dated June 23rd of 2026. The finding in the report is that Ms. McMillan is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge.
Not from the state.
Then at this time, based on that report, I am going to find Ms. McMillan competent to stand trial. Mr. Lewis, will she waive the formal reading of the indictment?
She does.
Ms. McMillan, you're charged with a third-degree felony offense of injury to an elderly individual from March 16th, 2026. And how do you plead to that charge?
Plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
No, ma'am. I'm just ready to do my time.
Now, it doesn't work like that. If you didn't do this, then you get a trial. So here's the thing before you go any further. When you stood over in front of the clerk a minute ago, you raised your right hand and you said you promised to tell the truth, the whole truth, right?
Yes, ma'am.
So if you're guilty, you're guilty. If you're not guilty, then we'll get your case set for trial. But I'm not going to allow you to plead guilty with something you didn't do.
Yes, ma'am.
Okay, so if you want to talk to Mr. Lewis for a minute again, that's fine. If you're going to take responsibility, then I'll ask the same questions again, but that's going to be up to you.
Yes, ma'am.
What do you want to do?
I mean, I don't have anything to say with it. I know I never touched him.
Okay, so then I'm going to delete this paperwork, and what we'll do, Ms. McMillan, is I'm going to set your case for trial.
Yes.
When I set your case for trial, Mr. Lewis is appointed to represent you at this point. He handles a lot of cases for me here as a appointed attorney. With your permission, I can release him and I can appoint another attorney who could get ready for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, then, Mr. Lewis, you're released. Ms. McMillan, we will get you an attorney appointed today. They'll be out to see you very soon to begin preparation for trial.
Yes,
All right,
ma'am.
you go back with the bailiff.
Yes.
And Mr. Smith, if you'll make a notation, make sure, obviously, that's, I mean, we'll see what the other attorney does, but I don't intend to keep that deal. I'm sure you don't either.
No.
All right,